All right, beautiful. All right, welcome everybody. Happy Pro Bono Week. If you're here for how to legally form a 501c3 organization, then you're absolutely in the right place, so don't go anywhere. We have a really great event in store today, and we're super excited about it. So I want to officially take this moment to welcome you to How to Legally Form a 501c3 Organization, hosted by Taproot Foundation and Trust Law during Pro Bono Week, which is a special week kind of celebrating the impact of this form of community service on communities around the globe. And so kind of not a more fitting way to celebrate this week than to kick it off with the wonderful speakers that we have lined up for today. My name is Kimberly Swartz. You can call me Kim. My pronouns are she, her, hers. I'm Taproot's Senior Director of Community Engagement, and I'll be acting as a bit of a moderator for today's event. So if you do have any questions for Taproot or for our speakers, tech issues, please do feel free to private message me throughout. And I'll try and keep up with things and then pass questions along to our speakers as well. But really, I'm thrilled to be joined by the experts that really will be leading today's event. We're joined by Emma Hunt, Trust Law's Legal Program Manager for North America and the Caribbean. As Legal Program Manager, she oversees the network of Trust Law's members and handles legal pro bono requests from nonprofit organizations and social enterprises. Emma identifies strategic human rights issues and scopes and manages the development and publication of legal research for the social sector. And Emma and her team regularly host legal workshops and events in collaboration with law firms and corporate partners and partners like Taproot. And so we're happy to share those out with our network as well when it's relevant. We're also joined by Fariha Syed, who's an associate with Kirkland and Ellis, LLP, where her practice focuses on debt finance and corporate transactions. Her pro bono work really focuses on nonprofits and immigration matters and small businesses. So we have a really wonderful advocate kind of speaking with all of you today. And then we're also joined by Sabrina Glaser, also from Kirkland and Ellis LLP as a partner there. Sabrina has 15 years of experience advising clients on ER/ISA matters and currently focuses her practice on that and fiduciary issues in connection with investment and pension plan assets. So throughout her career, she's maintained a really active pro bono practice focusing on the formation, operation, and then combination and dissolution of nonprofit organizations, including charities and schools. So we really have just a wealth of knowledge here for you today. And so we're going to go ahead and get things going. Although I do want to just kick us off with a quick introduction to Taproot, and then I'll pass the mic over to our wonderful guest speakers who will take us away. So Taproot was founded as a nonprofit in the early 2000s, really with this knowledge that there's a massive resource gap present in the social sector. So we have organizations who may have the solutions to the world's most pressing social challenges, but they simply don't have the financial means or staff capacity to fully enact those missions on behalf of our community members. And so our nonprofit exists to support other nonprofits in helping to close that resource gap by mobilizing skilled volunteers from the corporate space. So our nonprofit operates a full suite of business pro bono programs, focusing in areas like marketing communications, IT, business strategy, finance, etc. And we do that through partnerships with companies and philanthropic organizations, and through a platform which we call Taproot Plus, which I know many of you are familiar with. You probably joined this event because of your Taproot Plus account, and that's why you heard of it. But that said, all of our field research and best practices resources, they're all available free. Our programs and services are not available to all. So in order to participate in Taproot's nonprofit programming, you must belong to a registered charitable organization, a public institution like a school or a library, or be fiscally sponsored by a social good organization. So our team really was asking ourselves, how can more social good organizations qualify for our services? Because we want to democratize access to resources. We want more folks getting the support they need so that more community members can be served. And so we knew we wanted to help folks get registered as a 501c3 organization, which is why we turned to Trust Law, who is a global pro bono legal service of the Thomson Reuters Foundation in Kirkland and Ellis LLP, to develop this guide that I know many of you have downloaded, Legal Steps to Forming a 501c3 Organization. The guide includes step-by-step directions to form a not-for-profit corporation and apply for federal 501c3 status, allowing more access to Taproot's network of skilled volunteers and more access to the wonderful programs that Trust Law provides as well. And you'll hear about those in just a moment. So we've invited the authors of that guide to dig into the content further and answer questions about usage. So now that the stage is set, just a few logistics notes. We are recording this event. We'll share it with all registrants. You'll receive the guide to forming a 501c3 organization in the follow-up email. And please do use the chat or Q&A function throughout, as all of our speakers will be taking note of that, and we may have some time for questions at the very end. So with that, I am going to pass the mic over to Emma Hunt for a few words from Taproot's partner at Trust Law.
Thank you so much, Kim, for that super comprehensive and very wonderful introduction. And a huge thanks to everyone for having me here today during Pro Bono Week, which is a really exciting time for kind of people working in both legal and non-legal pro bono. I think it's great to be able to kind of share an amazing example of a fantastic pro bono project with you all this week. Just very quick from me, because I know we want to make time to hear from Sabrina and Fariha. But as Kim mentioned, Trust Law is a legal pro bono, essentially matchmaking service. We support 5,500 nonprofit and social enterprise organizations around the world, finding and sourcing free kind of transactional legal support. So anything that goes towards the behind the scenes running of an organization, employment, contract, IP, etc. We also do strategic legal research projects, and that could be internal research to help you understand new legislation in a space, or it can be an external guide or resource like the one we're launching today. So Trust Law was thrilled to hear from Taproot with their idea to kind of establish this guide, and really honored to link them up with the great team at Kirkland and Ellis to kind of bring it to life. It's a fantastic resource. We're sure it will have enormous readership. So just a big shout out and a huge thank you from Trust Law to everybody who was involved in pulling it together. And again, to all of you for coming today to hear a little bit more about it. If anyone on the line is interested in joining Trust Law or hearing a little bit more about our pro bono service, my email is going to be on one of the slides. Actually, I can see it right now in front of me. So please don't feel shy. We would love to hear from you. Send me a quick email after the event and we can connect properly then. But Kim, that's all from me. I'm happy to hand it back to you.
Perfect. Then let's go ahead and get rolling, and would love to invite Sabrina and Fariha to jump right in.
Right. If we could go to the next slide, please.
Absolutely.
We're just going to do an overview, talk about the steps to forming a 501c3, the alternatives to forming a 501c3, and then we can take some questions if we have time. Slide, please. All right. So what's a 501c3? Slide. Sorry, we're going to move quickly through the first few slides. So a 501c3 is a type of tax-exempt organization created under the Internal Revenue Code, and it's organized and operated to benefit a particular segment of people or a particular community, not to create a profit, and for one of a list of enumerated exempt purposes, including religious, charitable, scientific and the public interest, literary, educational, public safety testing, or national or international sports competition. Slide, please. So there are advantages and disadvantages to everything, and that includes becoming a 501c3. The advantages, you may know a handful of these. You don't have to pay federal income tax, and you may be able to avoid state and local tax as well. The donations to your organization are tax deductible at a federal level, and again, often at a state and local level, if applicable, to the giver. You're eligible for public and private grants, including grants from foundations, and you can't be personally liable for any of the debts that are incurred by your organization. The disadvantages are perhaps less well known. It's timely and expensive to become a 501c3. It can take 3 months to a year, depending on your processing time for your Form 1023, which is your application to the IRS. We're going to get into that in a minute. You will be subject to additional public scrutiny. Every year you have to file something called a 990, which is an information reporting tax return. And you're technically regulated by the IRS, so they could come in to examine you. And there are government restrictions and regulations on your operations. Means that you can't engage in some types of political activities like lobbying. You generally are limited to how much you can pay your directors and officers, and you have to track your activities, investments, and money transfers in case of an audit. Slide, please.
So we're going to go through the 11 steps to actually forming a 501c3. Step 1 is to form your entity. Now you might already have an existing corporation, which is good news because you can just skip to step 4. In the event that you have an existing LLC, you will want to convert that to a corporation. You can do so by filing a certificate of conversion and paying a filing fee. But if your state doesn't allow this, then you can undergo a statutory merger. We kind of go into more detail about that in the guide, and you can also just check your Secretary of State's website. And if you're starting from scratch, then you're going to form a corporation at the state level. Slide, please. So in order to form a corporation at the state level, you will have to file what's called the Articles of Incorporation. This is the legal document that forms the corporation. So you want to pick a name. It's good to be original. Make sure that your name isn't taken. Avoid political names. Your Secretary of State's website will also have information about what's allowed in the name and what's not allowed. You should also select a registered agent and office, which is where your official correspondence will go to. And most importantly is to appoint your board of directors. These are the people who are going to be managing your organization. So it's important to think about how many you want. The more directors you want, you have, the more viewpoints you'll have when it comes to certain decision making. It's also important to consider what kind of skill sets you want in your organization. For example, perhaps you need some people with fundraising skills or certain levels of business or legal expertise. So now is kind of the time to think about that. And it's just important to kind of figure out how you will want to remove them or how they will be appointed. And you can also put all of this in your bylaws, which we will discuss at a later time.
All right, there are a few fiduciary duties that are incumbent upon all directors. First is the duty of loyalty. That means that you're loyal to the organization. You're not trying to use the organization's resources to enrich yourself. You're, in it for the charity. Duty of care means that you're going to come to the table using a reasonable amount of preparation and attention to detail. If you're voting on a motion, for instance, you have read about what that motion is. You've read any documents that were sent to you prior to the board meeting, and now you're going to vote in a knowing manner. Duty of obedience is obedience to the mission and the law. And so this is basically keeping the organization's mission in mind when you're making decisions as a director, and also ensuring that you're complying with the law when you are acting as a director. Slide, please. So we're going to talk about the Articles of Incorporation briefly. This is your organizing document, and you're going to want to draft this with the Form 1023 in mind. It's important to do this correctly now, because when you go to the IRS, one of the things that they're going to ask you for is your Articles of Incorporation, and you're going to want to make sure that it contains your purpose, a clause that says that your main activity will be accomplishing the purpose. You're going to want to prohibit earnings to any shareholders, individuals, directors. You're going to want to prohibit any illegal activities and limit your lobbying activities and all of that. That'll all come down to whether the IRS is going to decide that you are fulfilling a charitable purpose or not. You're also going to want to make sure that your articles contain a dissolution clause that says what will happen if the organization ever ceases to exist. And this is important because they want to make sure that if you are ever dissolved down the road, that you're not just distributing out your proceeds to whoever the directors happen to be at the time or the founder. Slide, please.
The other test that the IRS uses is the operational test. So this looks at whether your organization is actually accomplishing one or more of the exempt purposes that we discussed earlier. It must serve a public, not private interest. The net earnings can't benefit any private shareholders or individuals. You can't have any substantial involvement in influencing legislation, and you can't be participating in any political campaign. Once you're pretty sure that your purpose will meet the requirements of the operational test and organizational test, you can assign an incorporator. This is the person, they only have to be at least 18 years or older, and this is the person that will be signing the articles for you and actually filing it. And once this is filed, you've formed your corporation, and the next step is going to be to apply for federal tax exempt status. Slide please. So step 2 is to obtain your EIN, your federal employer identification number. I think of it as like the social security number of the corporation, sort of. You need this to open bank accounts and to file for your tax exempt status. So it's really important to not skip this step. And you can easily apply for one by using Form SS4. Slide, please.
Your next step is going to be drafting your bylaws. Bylaws are the documents that tell you how the organization is going to be run. So this is where you set your guidelines about who's going to vote, who has the power to make what decisions, when you're going to vote, how you're going to vote, that sort of thing. You will decide if you want to have members or not, and we'll talk about that in more detail in the next slide. You'll decide what your fiscal year start is, and that's any 12-month period. Most common are January 1, which is, the calendar year for individuals, and July 1, which is the start of the calendar for a lot of governmental organizations. So if you are relying heavily on governmental grants, you might want to pick a July 1 start date. You will want to set out how often the board meets. Is it going to be monthly? Is it going to be quarterly? And what the notice requirements are. Can you send an email? Do you have to send registered mail? Please don't make yourself send registered mail. The responsibilities of any officers will be in this document, and the term of those officers for the board and how they will be removed. So those are all important things to set out at the start. Slide, please. So back to the membership, non-membership. It is common for nonprofits that focus on advocacy to be member organizations. Service organizations are much more likely to be non-membership based. The main difference is that if you have members, those members are going to have rights. They're going to have voting rights on major decisions. They can elect board members in a lot of states. They would have to approve any changes to your articles of incorporation or your bylaws. And they'd have to vote on mergers, dissolutions, strategic alliances, that sort of thing. And there are rules about each member's right to vote and how that's carried out. In a non-membership organization, you don't really have that. The board instead makes the decision, and new directors are elected by the existing members of the board. So membership is, I wouldn't form a membership organization lightly, because at best members can make the process slower. And at worst, they could actually hijack the organization. There are some organizations for whom members make a lot of sense and, work really well with the mission, particularly if you are an organization that needs to have buy-in. It's important to have buy-in from a particular community. Then membership organization might be for you, but I would talk about this with your counsel or advisors. Slide.
So there are a number of policies that we recommend putting into your bylaws, either because your state is going to require you to anyway, or because Form 990 asks you if you haven't have it in your bylaws. So the first one is a conflict of interest policy, which is exactly what it sounds like. It's when the aims of the organization and the aims of another party are incompatible, and when advancing one's interest becomes more important than advancing the interests of the organization. So this could come into play, for example, if a board member owns office space and the corporation is looking to rent some office space. As a board member, his interest should be to get the lowest rent possible for the corporation. But as a landlord, his interest would be to increase and maximize rent. So this can be seen as an excess benefit transaction if the board member ends up getting an economic benefit and the corporation overpays for the rent. And if this does become an excess benefit transaction, it is subject to excise tax. And this is kind of looked down upon by the IRS, especially because you can lose your tax exempt status over this. It's also a public transaction, so it can upset a lot of your donors and generate negative publicity as well. So it's important to adopt a conflict of interest policy to avoid this situation. Slide, please. So we alluded to Form 990 before. Just an overview of Form 990. You have to complete this form annually once you obtain your 501c3 status. It is providing the public with all your financial information. So your revenues, expenses, assets, liabilities, money going in, money going out, all of that is public. So the IRS uses this every year to determine whether you still qualify for your tax exempt status. And one thing that is important is that if it sees that your management is actually overcompensated, you can lose your status, which is why we recommend forming a compensation committee. Slide, please. So it's helpful to form this committee to avoid losing your tax exempt status. If you have no paid employees, you don't actually have to do this. But in the event that you do have paid employees, it's very helpful to form a committee. The committee can review the compensation of all your directors and officers, employees, independent contractors. They should be disinterested and not paid. And they can make sure that the compensation of all these employees are reasonable and tied to the achievement of mission-related goals. Slide, please. Another policy that we recommend adopting is a whistleblower policy, which is policy that encourages people to report any wrongdoings or illegal activities that they may witness or be aware of. Usually there is a designated person who will handle such reports, which is the title is usually a compliance officer, and it also should tell the person how it is protecting the person from retaliation and detail all the procedure for investigations. All your employees in DNO should sign a statement that they received a copy of this policy and they're aware of it. And just in case that they do witness anything, they are aware of the procedures to undergo to report it. Slide, please. Another policy that's not required, but Form 990 will ask you if you have one, and if your state requires it, you'll have to do it anyway, is a document retention and destruction policy. This ensures that all your documents are retained pursuant to any applicable laws. In the event that you are undergoing a legal or governmental proceeding, you also want to make sure that you have all these documents retained and you haven't inadvertently destroyed them. The policy should identify who is going to be maintaining the storage and ensuring that all these documents are in place. And usually the documents that are retained are accounting records, donations coming in, your articles of incorporation, all your organizational documents, basically like your bylaws, and any activity records of fundraisings, money going in, money going out, everything should be retained.
All right. So once you have all your policies in order, you are going to hold your first organizational meeting. And this will be the meeting where you decide, if you haven't already, who the board of directors are going to be, and you're going to settle a lot of housekeeping items. That's including resolutions about opening your bank account, authorizing your 1023 application for federal and state tax exempt status, adopting your bylaws, so on and so forth. Adopting any of the policies that you have drafted. This doesn't have to be in person, this meeting. It can be documented through a written consent if that's permitted under the applicable state law where you formed. However, I think it is a good opportunity to get everybody in the same room and just discuss how you're going to move forward. So that would be my recommendation. Slide, please. Next up is applying for federal 501c3 status. This is the Form 1023, which I've been talking about throughout because it is a focal point of getting your tax exemption. There are instructions on the IRS's website, and you have to electronically file. You can't do a paper form any longer. The form is public, and if your charity is sufficiently, if your income is under $50,000 in the past 3 years and you expect it to be $50,000 for the next 3 years, you can file a 1023 easy, which is a shorter form. Once you obtain that IRS determination letter saying that your application has been approved, your organization is tax exempt, and anybody who has made a donation to you since your formation can take the deduction for that donation. Slide, please. Next up is you're going to register as a charitable organization with your state attorney general. There are several state attorneys general who require you to register if you're going to be soliciting within the state. And that includes campaigns, it includes in-person fundraisers. I would say that if you are targeting any particular area for fundraising, that you should look into the laws in that area and make sure that you've done everything you need to do to register to raise funds there. You may also have to apply for state and local tax exemptions. Usually that means that you're just sending your determination letter. Slide, please.
So maybe after all this, you're like, I don't want to form a 501c3 at this time, or you're still thinking about it. There are other alternatives to a 501c3. I want to kind of focus on partnering with a fiscal sponsor because some people might not know about this option. So a fiscal sponsor is a nonprofit 501c3 exempt organization. So they already have their 501c3 status, and they can actually work with you and sponsor you for certain projects. So this is good for someone who is perhaps waiting for their 501c3 exempt status, and they just want to get involved and do some projects and get started on their work, so they can partner with a fiscal sponsor while they're waiting to get their status from the IRS. This is also good for someone who isn't really sure if they want to form their nonprofit, or they don't know what direction they want to take their nonprofit to at this time. So working with a fiscal sponsor is kind of a good way to experiment a project that you want to do. For example, if you want to work with amputees in Sierra Leone and there's a nonprofit that kind of already does that, you can work with them and see if this is what you want to pursue for your own nonprofit. And another way to benefit from this is if you do have a 501c3 nonprofit, but you don't have the resources to do like bookkeeping or administration services, accounting records, you can partner with a fiscal sponsor who can provide these services for you. The cons are that you'll likely have to pay them a fee for these services, and the funds that the fiscal sponsor gets are like they will be directing all the funds. You don't really have a say of where these funds are going to go. So they control all the funds. And it's also the case that the organization's goals have to exactly match with the goals that you're trying to do a project for as well. So if going back to the amputee example, if they're working with amputees in Sierra Leone and you want to provide clean drinking water to the people of Sierra Leone, that's not going to be an exact match. So they're unlikely to sponsor you for that reason. I think another pro that I didn't touch on was that they can also receive a lot of grants that you normally wouldn't be getting outside of partnering with a fiscal sponsor. So that's another pro. The other examples, alternatives to a 501c3, you can always work with an informal group, volunteer and donate money with organizations, or work with existing nonprofits. And working with a social enterprise. These are for-profit organizations that donate their money to donate some of their profits to a good cause. So Tom's is an example. Figs, those are for-profit businesses that share their proceeds to a good cause.
I do see that we have some questions in the chat. Should I try to run through as many questions as I can in a couple of minutes, or?
Yeah, if we wouldn't mind just doing a little bit of a speed round for some of these questions that have popped in. So for example, the meeting that you were discussing where you have to do documentation around the bylaws, there were some questions around there, namely what constitutes written consent for this organizational meeting, and then what would need to be documented about that meeting.
The written consent is a state requirement, so it's really going to vary by the state, but it would typically be a document that says what you've agreed upon and what measures you've passed, what resolutions you've passed, and then it'll have everybody's signature, which might be able to be an email signature depending on the state. I would suggest that you document any meeting that you have, that your board has. Even if it's just a meeting of an executive committee. I think committee meeting minutes is not always required, but is helpful because it lets people in the future, and you want your organization to survive in the future, see what you've done in the past, how you got to where you are. So I would suggest always keeping minutes, but certainly at the initial organizing meeting.
That makes a lot of sense. And then a question that was getting a lot of different folks chiming in was around, can an organization work with multiple fiscal sponsors?
Oh, that's a tricky one. So part of working with a fiscal sponsor is an agreement with them around your own fundraising. And if they are going to do fundraising on your behalf, you'll have an agreement about that too. What makes it tricky to, as a young organization, work with multiple fiscal sponsors is that they'll typically want a haircut on all of your fundraising. And if you're giving more than one organization, 15 to 20% of your fundraising, you may not be able to sustain yourself, which ultimately some people enter into fiscal sponsorships knowing that they're no longer able to carry the organization independently and that it's a first step towards a merger. But if that's not the direction you're going in and you're in fact just starting out, that's really tricky, and I would generally advise against it.
Sounds like that's going to be very helpful advice for a few folks on the line. And then we had a question come in around any additional legal or other considerations to consider when operating a 501c3 in conjunction with a 501c6.
I'm not sure that I'm aware of any resources to that end. And it sounds like in that case, you're probably going to want to find counsel or pro bono counsel to help you with that particular situation.
Yeah, and I can also just voice Council of Nonprofits has some good resources available for organizations operating under 501c6 status. So that's a resource that you could dig into. And I know we're already a few minutes over time. So I just want to be cognizant of the time of our speakers because they are in the midst of a very busy pro bono week themselves. So if we could maybe do one more question, and then again, in the follow-up email, we're going to share the resource that Fariha and Sabrina and the folks at Kirkland and Ellis have helped put together on behalf of Trust Law and Taproot. So we will share that resource out. And we'll share some other resources as well, including legal pro bono support via Trust Law and business pro bono support via Taproot. So let's finish with this really good question from Evan around what are the advantages of hiring a lawyer or recruiting a pro bono lawyer to speed up this process of forming an organization?
I would say familiarity with local law. So yes, people can get to fill out their 1023 themselves. You can find templates for just about anything. But where boards get stuck if you don't have a lawyer on your board is, what does our first meeting have to look like? How many directors do we need? What policies do we need to adopt? Particularly in New York State, there was an overhaul of the nonprofit law a handful of years ago, and it imposed a lot of operating requirements that have been tricky to navigate for non-legal folks.
Yeah. All right. Thank you for going rapid fire through some of those questions that came in. I know it was super helpful for folks on the line, and we'll make sure to share out more resources in the follow-up for this event as well. So I hope that everyone will please just join me, and a massive thank you to the Trust Law team for their partnership in creating this resource and this event, but also for Sabrina and Fariha for donating their time, talents to us in the creation of the guide, but also in facilitating this event. So massive thank you, and just filled with gratitude for all that you've shared with the nonprofits on the line and the soon-to-be nonprofits on the line.
Thank you.
All right, everyone.
Thanks, everyone.
I hope that you have a great rest of your day. Really appreciate you sharing your time with us. Thanks all.